Good evening, ladies and gentlemen. My name is John Leonard. I'm Chairman of the Board of Appeals. We have our first hearing at 7 o'clock. It's the hearing at 16 Amor Avenue in Milton, Massachusetts. This is an application under General Laws Chapter 40B, seeking a project on Amor Avenue. The matter has been continued to this date. Let me just introduce my fellow board members with me on this application. Is Board Member Brian Conley and Board Member Virginia Donahue King. At the last hearing of the board on this matter, which was a procedural hearing discussing logistics and scheduling further hearing dates, we had Mr. Schomer present on behalf of the applicant, and Mr. Schomer and the applicant agreed that as a result of the number of 40B projects pending in Milton, Massachusetts, the board was eligible to stay the opening public hearing dealing on the merits of this application pursuant to the statute, which is 760 CMR 56.05, 3 in parentheses, which indicates that if there are more than 3 40B applications pending and the applications total more than 300 dwelling units, that we can stay hearings until we dispose of one or more of the principal applications that are already pending. So we continue to this evening to have a status report. And I can report to you that the 3 applications preceding Amor Avenue are still pending, though in the Ice House application, the evidentiary hearings have ended and the discussion of the decision is in order. So we've told Mr. Schomer that the board intends to continue this hearing tonight until September 30th to reassess where we are in the 40B process. And Bev, is that going to be at 7 o'clock? Is that the preferred time for this?
Yes, we'll do it in the same order. Yes.
Okay, so let me ask whether any of my board members have any questions or comments and otherwise wish to be heard on continuing this matter until September 30th at 7 p.m.
I think that's fine, Mr. Chairman. I mean, I know they had agreed to extend month to month, so their letter had said we wouldn't meet next till October. I'm just mindful of it may well be in October we're doing another continuance. So I don't know if we want to defer this until an October meeting, but I'm available on the 30th, so I'll defer to whatever approach you'd suggest.
Yeah, I think we chose the 30th because it fit in best with our scheduling.
Okay, and that works for me.
Yeah, and I think that in all probability, we're still going to be in this situation of a stay of this proceeding for at least another month or so. But we discussed with Mr. Schomer this date, and it was acceptable to the applicant and fits in with the board's scheduling of other applications, particularly the next application, the 715 application, which is going to be continued with Frank O'Brien as acting chairman. Mrs. King, do you have any questions or comments on the continuance of this matter?
Actually, I think this is Giselle Joffre's case with us, Mr. Chairman, and I think Ginny is just on in attendance waiting for the.
I'm sorry.
Right.
I think you're right.
Yeah.
So that's why Giselle was here at 7 o'clock and wanted to get back to her mediation. Okay, so Giselle certainly didn't have any objections to continuing this. So all those in favor of continuing this matter to September 30th at 7 p.m. For a further review of the status of pending applications, please say aye.
Aye.
And Giselle, I think by implication, has indicated that she agrees with this. So Bev, unless there's further matters to come before the board here on this particular application, and I think there isn't any. Are you in agreement with that?
Yes, there's nothing else going on. Yeah.
Okay, great. Then Ned, Mr. Corcoran, you don't have any comments that
I
you
have nothing. Thank you.
Okay, great. So
Okay.
we're going to adjourn this hearing to September 30th at 7 p.m. and want to thank everybody for participating. And we'll make sure that Mr. Schomer gets actual notice from the
Absolutely.
from Bev. Okay, folks, thank you. And we're going to continue the hearing to the 30th. And Beverly has a 7:15 scheduled for 936 Brush Hill Road. And we will see you at, I'll particularly see you at
7:30.
at 7:30 with Mr.
Great.
Cohen and Mrs.
See you in a
King.
bit. Thank you.
Okay, thanks, guys. Yep, bye-bye.
See you in a bit.
Good evening and welcome to the Milton Board of Appeals. My name is Frank O'Brien and I will be chairing this hearing on a 40B application relative to the locus at 936 Brush Hill Road. Joining me here this evening are my fellow board members of Virginia Donahue King and Ted Daber. The purpose of this particular hearing is purely logistical and scheduling in nature. No specific public testimony will be taken. Pursuant to the decision made at the last public hearing regarding this, and consistent with the provisions of 2 MR 760 section 56.05 subparagraph 3, the application regarding this property, again at 936 Brush Hill Road, is going to be deferred. The regulation allows the postponement of pending 40B applications when there is a series of applications containing 300 or more units within a particular community. That continues to be the case here in Milton, although I would note somewhat optimistically that the application involving the so-called Ice House property is moving along to the decision stage. Nonetheless, we remain at the point where a continuance of this particular application is both appropriate, necessary, and has been agreed to by the applicant and the applicant's attorney. In that regard, the proposal is to again continue this application with a further hearing date scheduled for September 30th at 7:15 p.m. At that time, we will again ascertain the status of the applications and again hear issues related to scheduling and other logistics involving this hearing. So with that, I would ask if one of my fellow board members would make a motion to extend the consideration of this particular application to September 30th at 7:15 p.m.
So moved.
I have
Second.
a motion and a second. All those in favor say aye.
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 It's unanimous. Ms. Sutton, if you wouldn't mind letting the interested parties and their attorneys know of this decision. Before we adjourn the hearing, let me ask my fellow board members if they have any questions or comments they'd like to make relative to any matter involving this pending application.
I have none at present.
I have none either, and hearing none, that concludes our business for this evening, and may I have a motion to adjourn?
So moved.
Second.
All in favor, say aye.
Aye.
The
Aye.
ayes have it. It's unanimous, and this hearing is adjourned. Thank you all, and good evening, everyone.
Thank you. Good
Good
night.
night.
Good night. Good night, Ms.
Thank you, Sharon.
Good evening, ladies and gentlemen. My name is John Leonard. Welcome to the meeting of the Board of Appeals of the Town of Milton regarding the application of 485, 487 Blue Hills Parkway. At least that's the location of the properties, otherwise known as the Ice House. With us this evening, two fellow board members, Brian Conley and Virginia Donahue King. And I see that Mr. Adam Brodsky, attorney for the applicant, is also present. We ended the evidence portion of this application, and we continued it until this evening at 7:30 in order to discuss the proposed decision. We have 30 days from the date of the vote to close the evidence within which to wrap this case up, so that we're in deliberations at the present time. And so we're not entertaining public comment on this particular application. What we did receive from Judy Barrett, the board's consultant, is the last iteration. I think it perhaps is the third iteration of a proposed decision on this application for a comprehensive permit from the applicant BHP Trust LLC. The property is located at 485, 487 Blue Hill Parkway. And we received on September 9th, that's this morning, a draft decision from Miss Barrett. The decision is 23 pages long. And so let me just ask my fellow board members whether they've had sufficient time to review this particular draft decision and their notes and maybe some other hearing data. And do they feel comfortable discussing this particular draft decision at the present time? Mr. Connolly, do you want to be heard on whether you've had time to review this adequately?
Yes, Mr. Chairman, I have had a chance to read it, and I wish Judy was here so I could compliment her on her work. And I have a handful of comments. I don't think anything significantly substantive. Suggestions to make for some edits, but I'm ready to discuss it if the other board members are.
Okay, Mrs. King, how about you?
Yes, I'm ready as well. Unfortunately, I've got my tablet here and I'm trying to get the decision that she wrote so well up here, and for some reason it's not working for me. So I won't have it in front of me, but I will try to not let that be an impediment, excuse me.
Okay, well, look, if it becomes an impediment, let me know. And let me just ask Mr. Brodsky, and just state for the record, we did receive an email from Mr. Brodsky proposing one change on behalf of the applicant dealing with dumpsters and the like. We'll get into that. So we want to thank you for that. But have you had an opportunity, Mr. Brodsky, to review this this draft decision and send us any comments that you may have?
Thank you, Mr. Leonard, and good evening, everyone. I'm here this evening with Kate Driscoll, who's a construction manager for the project, since Mr. Bosworth and Paul Driscoll are not available. And we have had an opportunity to review the decision. As you noted, we had one last change to propose having to do with the dumpster. But otherwise, we agree that Ms. Barrett did a fair and fine job in drafting the decision, and we have no further comments on it. Thank you for the opportunity.
Yeah, and that those comments also relate to Mr. Bosworth and Mr. Driscoll himself. Is that true? They've had an adequate opportunity to review this.
Yes, sir. The entire team reviewed this, so you have all of our comments.
Okay, great. We appreciate that very much. I did have a chance to read it. I have several small comments. They're in the nature of edits. And I think I'd like to pick up on Mr. Brodsky's theme. On behalf of the board and my fellow board members, I really want to thank Judy Barrett for her hard work on this case and her multiple iterations of a draft decision. I think this is, the preparation of this is exemplary. I think it would take me a month or more to do something that would be only half as good as this. It shows Ms. Barrett's tremendous experience in this area, and just in terms of the format and the substance of it is, I think it's a virtual art form, and it shows a lot of hard work and discipline dealing with factual issues and some very technical issues as well that I think brings credit to Ms. Barrett and her company and herself, and also is really a great benefit to the town and also to the applicant, because this applicant has waited a long time on this particular application and been very helpful and very cooperative. And I would feel terrible if this took 3 or 4 weeks or more. So I think, thank you, Judy, and we'll tell her that personally. So let's discuss the application. My comments are minimal, I'll tell you, though well, why don't I do this rather than making humor here? Why don't we hear from Mr. Connolly first? What are your comments, or what do you want to discuss about the draft decision, Brian?
Sure. Thanks, Mr. Chairman. And I guess just before we go through, I guess just to get on the same page and what our sort of process and goals are here, I think we're in a place where we've certainly studied the project enough, closed the public hearing. We've all had a chance to read the decision. And I think the goal is to go through it using Judy's draft as a starting point to see if we have consensus on changes to the decision, right? And then I think we would discuss the changes we would make and then be in a position to vote on the decision this evening. Is that the plan? And so we would discuss the changes and then we can report them to Judy, or I could even volunteer to make revisions based on our discussion, or do I not have the process right?
No, I think you have the process right. It really just depends upon the significance of the changes. For example, when I reviewed this, I noted that your name was misspelled. You're named as Connelly, which is probably from the north of Ireland, but your real name is Connolly, Connolly.
That's really all I wanted to fix. I'm good if you get that all squared away.
Yeah, well, I thought you'd like that. That's very important. But as long as they're relatively insignificant edits, then I think we can vote on the application subject to those edits being made and a final decision being reviewed by us, and but for to make sure the changes have been made.
Yeah.
And then we can get it signed up. But if we have something of substance, then it may take. It may be a little more complicated. So why don't you run with your list?
So why don't, maybe a good approach, we could just go page by page, and the three, instead of going through it 3 times, we can, when we're in each section, if any of us has a comment, we can share it. And when we get to the end, if we're at a point where we'll know then if we have anything substantive that you were asking about or not, and can make the decision then. Okay, so and I'm happy to start, Mr. Chairman, if you'd like, and drive through the process. So on first page, I think we had a meeting on in paragraph 3 on page 1. I think we also met on August 5th. So I would just add that to the meeting list.
Okay.
Um,
Do you have any comment there? I think we did meet on August 5th. Hold on one second here, as I get my tablet. We did. We met on August 5th as well as the 19th, and that was at 7:15 in the evening. So that's on paragraph 3, Brian?
yeah.
I got it confirmed also.
And that's all I had on the first page.
Okay. I'm in agreement. Jenny, if you have any comments, just speak up. If you
Because
got
I'm not, I haven't been able to pull it up. No, it keeps going. It doesn't like the WinZip file for some reason.
Jenny, would it help if I could send you an email now with a Word document attached? Would that be helpful to you?
Yeah, that would.
Okay. I'll do that
It's
right
always
now.
worked before. I thought I was great in not printing all of these pages until I needed them, but I guess I needed it today.
Okay. I was supposed to read your email address over Zoom, but I don't know if that's an appropriate thing. So I'm pretty sure I got it right. And I'll send this through you now, and I will copy
jump
John, and I'll copy Attorney Brodsky, his email address. And we'll get right back to this. Thank you. 1 second.
Thought I was doing really well today with my technical stuff, getting here on time and everything, and and now my tablets let me down.
Well, when did you get the bill from Mr. Connolly for his service? You won't be laughing as much.
No, I guess not. It's still not here.
Okay. I've just clicked send to you, Jenny, copying John and Adam. All right. Well, why don't we keep moving ahead while we're waiting for that to come through? Because I don't think, and then we can come back. Jenny, if you had anything on the earlier pages.
Yeah.
So on page 2 in paragraph 8, thank you, Mr. Chairman, for correcting my names with 2 O's. And then I had a general question, I guess, that runs through the articles 2 and 3, pages 2, 3, and 4. There are a number of just statements about the condition of affordable housing in the town of Milton that I and Bev, maybe you can confirm this, or Mr. Chairman, we've had our consultant sort of verify all this information, so we can rely on our consultant's advice in terms of describing, all these findings we're making in the jurisdictional findings and governing law section.
Yeah,
I think that's fair.
I think it's, yeah.
I know Judy has researched this history.
Okay.
But what I think we should do is if we don't question any of those, I will speak with her tomorrow and just get a confirmation that data that she has secured and that it's presently accurate.
Great. Okay, then I have nothing else on page 2, and on page 3 of the decision is my next comments.
Okay, page 3.
And in section 13B, where this is the clause reciting the provisions of Chapter 40B that would provide to the town, a basis for not being obligated to provide a comprehensive permit. And it says, we have no evidence that the existable affordable housing units are on sites which comprise less than 1.5% of the total land area. I think that's meant to say more than 1.5% of the total land area.
I think you're right, but that's something that should be checked with Ms. Barrett.
Okay.
But I think-
I'm gonna minimize and see if Judy, if there's any chance she could come on. Would that help? If I sent her an email or no?
I don't know. It's
Okay.
I don't think we need her on this. We don't need her at the present time. Let me ask you a silly question, Brian. You see in paragraph 13,
Yes.
it says that to meet the statutory minima. Should minima be italicized there? Or is that my Jesuit background?
I will defer to your capitalization expertise at any hearing, Mr. Chairman.
I don't know. It just stuck out at me. I'll check that. And but I think you're right on B. But I'll check that with Judy.
Okay.
Are you all set on page 3?
Yes.
Okay.
And then I do not have any other questions until page 6
Okay. Yeah, well,
in Article 6
Ginny,
conditions.
let me ask Mrs. King. Ginny, have you received the email?
No,
from-
I haven't.
Oh, good, great.
Yeah. I wonder if. I can print it probably from my computer. The bigger one that does big files better. But shall I run and do that?
No, you know what? I'm realizing I sent it to the wrong person. So I'm gonna send it to you now. I should have read it over Zoom. We would have avoided that. Sorry. I've got a very confused person probably wondering why I'm sending that to them. Hang on. Okay. Okay, I've just resent it to you. So hopefully you'll have it momentarily.
Great. Thanks, Brian.
Yeah.
Oh, come on. There it is.
Yeah.
Oh, good.
She's not only did I use the wrong email address, I called you Judy, Jenny. I'm having a tough time here. So gotta work on being on a zoning board and typing at the same time, I guess.
Oh, goodness. That was
Brian,
good.
Okay,
Brian,
I've
you gotta
got-
be
I've got
very
it now.
careful.
Got it now.
Ginny's gonna go into military mode on you.
I know, I gotta be careful.
No, I don't carry those big guns.
So Ginny, we just finished page 3, and then Brian was suggesting it's what 4, 5, and 6. Brian, you didn't have any questions on?
Correct. I have nothing further until page 6 when we get to the conditions, Article 6.
Yep, I have nothing on 4, and I have nothing on 5. So Ginny, why don't you take a look at 4 and 5 and see if you have any questions there.
No, I'm good with that.
Okay. So you're on page 6, Brian. Where do we go from there?
And maybe this is just another confirmation point. I just wanted to confirm that the plan list that's here was the last set of plans we have. I'm sure the civil plans, which have a April 18th revision date, must be the last set. And then the architectural and landscape plans are July dates. And I just didn't know whether we also had, is that the complete set of all plans? Is it just civil? I know there's so many sheets of plans within the various sets we got. Did the civil and the architectural and the landscape catch everything? Was there anything, for example, in the transportation study we had that would not have been encapsulated in the civil plans? And I think the answer is probably no. I read this and thought that probably looked right. And so if we had, I guess, a follow-up question, John, for Judy, it would just be, again, or for Tim, just to say, are these, just to double confirm, there's nothing else missing from this list. I'm guessing by how thorough everything else was here that that's the case.
Yeah, I would assume the same thing, but I'm in your position, Brian. I don't have the plans in front of me, and going into the files on the public record on the internet, trying to verify that it could be a dangerous thing. So that's a point for Ms. Barrett. Okay, so do you have any further comments on page?
And
7?
then just a spelling error just on in A2 in the second line. It should be successors and assigns, plural assigns.
Yeah, no, you're right. That one I missed. It shows you what your real estate experience brings home to roost, Brian. Good. How about page 7?
I have nothing on page 7.
Okay, neither do I. Bev, I'm sorry, Virginia, Mrs. King.
All set with that.
Okay. Page 7 is in. Page 8.
So on, I guess my first sort of substantive edit, and I guess this is in paragraph A9, which starts in the bottom of page 7 and goes to the top of page 8.
Yep.
This is the paragraph that says, all the obligations are binding on the successors and assigns of the applicant, and run with title to the land, which is right.
Yep.
One thing that's on my mind is, because this is a condominium project, if all goes according to plan, the developer will sell all the units, and so it's going to be the condominium association that will be looking to follow to follow all of the conditions that haven't been completed prior to construction. And what's helpful, we do see later on that there are requirements that the condominium documents be reviewed with town council. But I would just like to add, just for clarity, where it says this is binding on the successors and assigns of the applicant, that we just add in parentheses, including the condominium association, so that it's understood by unit purchasers in the future that this is not something that goes away when the developer goes away, but it's something that the association is going to be responsible for complying with, after the building's been occupied.
Okay, let me just ask you specifically, where does that go?
Yeah, so after the words on the top of page 8, upon the successors and assigns of the applicant, comma,
bear with me now.
I would, where I would put in, so the sentence opens, the provisions of the comprehensive permit decision and conditions shall be binding. That's the end of my page 7. And then my page 8 says, upon the successors and assigns of the applicants. I don't know if your pagination is the same as mine there.
I'm having, maybe I should see my eye doctor.
Or maybe we shouldn't just reference page numbers. If you have just paragraph A9.
Yeah, I do, but mine's, it says, in the event that the applicant self-transfer.
Oh, right before, it's the sentence before that one, John.
Okay, that's. So
immediately preceding.
Okay.
Yeah, so it straddles the page.
Okay, here we go. It's at the bottom of page 7 in mine.
Yeah.
It shall be binding upon the successes and the signs of the applicant.
And right there,
Yep.
after I put, in parentheses, including the condominium association.
Okay, I mean, that makes consummate sense to me. Ginny, do you want to be heard on that suggestion?
I agree with that because, sometimes we don't think of a condominium association as something that follows on as in ownership of a development like this. So I think that's a good addition, Brian.
Okay, good. Thank you, Brian. Where do we go from here?
And then in A10, where we have a provision that makes clear that the town is not responsible for maintaining, the sidewalks, driveways, drainage, et cetera, which is a good condition. It says they shall remain private in perpetuity. I just wanted to make sure that I assume the sidewalks that are on Blue Hill Parkway are public sidewalks. And I don't know if Attorney Brodsky knows this. Does the private land, does the private parcel end before the street side sidewalk begins? Because I think we don't want to say that the sidewalk is private in perpetuity. We do want to say that the sidewalks that sort of, approach the building and surround the building, those are private, subject to private maintenance. But I think the sidewalk, the traditional sidewalk that runs along the street would not be private.
No, I think you're exactly right. It's a question of what the so-called approved plans serving the project actually show, where there's a clear line of demarcation as to the ownership, because I agree with you. I think the ownership of the so-called sidewalk in front of this property probably is town-owned and not owned by the applicant.
I think the right answer would be just to have words that you could maybe even at the end of the paragraph just say that for clarity, the sidewalk running along Blue Hills Parkway shall be public, but the applicant shall be responsible for its routine snow removal and maintenance.
Mm-hmm. Just bear with me. Ginny, do you want to be heard on that?
Well, I guess there's nothing that says you have to shovel your sidewalk in front of your house, but I guess by convention everybody does. So I don't know if we can put that in there or not. I'd like to, but I don't know if that is appropriate.
I thought there was a rule or an obligation on parties to clear their own sidewalks. Maybe I'm.
No, I think it may depend on the community and the statute or resolves that the Board of Select Persons or whomever is the governing authority may have promulgated for the safety of the public. I just am not sure, candor whether the town of Milton has adopted a requirement that its residents clear and maintain, in a loose sense, the sidewalk in front of their houses.
The other thing is
for safe passage. I just don't know the answer to that.
Blue Hills Parkway, for all we know, might be the sidewalks. It's a busy road, so the sidewalks may in fact be done by the town anyway. I don't know, which makes it all moot, but we don't know that.
Well, it goes deeper than that, doesn't it? Is Blue Hill Parkway is it a town road, or I don't think it is. I think it's a state road.
It's a, yeah,
DCR Road, right?
well, it used to be an MDC road. I'm not sure. Recreation.
Well, maybe, yeah. Maybe I can say it in the negative. I think my real priority here is just to make sure it's on the record that it's a public sidewalk, not a private sidewalk that's not to be, accessed. That's my main point. And I suppose if we don't want to go so far as to say that the town I think it's a reasonable condition to say that the applicant would maintain its sidewalk. At a minimum, we could say that it's not the town's obligation, just so we don't imply we're putting some special duty on the town. But I would think it wouldn't be a controversial condition here to, for the safety of the residents, if nothing else, to have them have a duty just to keep it clear.
Adam has his hand up.
Yeah, sure, Adam, we'll recognize you. I know this is not supposed to be a back and forth, but maybe you can help us with your experience dealing with sidewalk issues.
Well, thank you, Mr. Lynn. I was just going to answer Mr. Connolly's question to the extent I could. And I'm looking at the existing conditions plan, which does not show the sidewalk on Blue Hills Parkway as being located on the locus. Therefore, I assume it's located within the right-of-way for Blue Hills Parkway. It's not called out as a detail on the plan within the layout, but it's certainly not shown on our property. I just wanted to point that out.
Thank you. And that makes sense. And I thought that would be the answer, but we've written this to say that all sidewalks shown on the plans, right? Which I think would cover sidewalk, whether it's on public land or not. So maybe the right answer here, and I think that is the case, is we don't really need to get in to maintenance if that makes other board members uncomfortable. I just do think it's important for us to just make clear that the sidewalk running along Blue Hills Parkway is not private.
Okay. Just bear with me. That eliminates a lot of testy issues, Brian.
Okay.
Okay, do you have any, is that satisfactory to you, Jenny?
Yes, it is.
Okay, great. Do you have any other comments on page 8, Brian?
I do not.
Okay.
I had one on A11. We're saying that to the extent snowfall exceeds the capacity of the designated snow storage on the site, the applicant shall truck the excess snow off site. Do we need to put signs in there because the applicant may or may not be around at that point, and it's a condition that has to be met?
So I think it's a super important point, Jenny, and I think the way to do it is not for us to try to hunt every particular obligation that would run to the condo association, because then if we could catch some or miss some. I think the way to do it is at that where we did it up front, where we just said all obligations run to successors and assigns, including the condo association.
Okay. Okay.
Mr. Chairman, do you agree with that? So we don't need to,
Yeah, I agree with that.
right? And we don't have to create ambiguity about if we miss one in some other place, were we limiting where it applied, right? So
And that's inevitable. That's going to happen.
Yeah.
Brian.
yeah.
Okay,
I agree.
sorry. Tim has his hand up?
Sure.
Tim Zawinski, yes.
Great.
Oh, sorry. I didn't want to chime in too much, but I was wondering about the sidewalk issue. If we wanted to go back to that for just a minute, if it would make sense to just sort of like add a reference to sidewalks on the project site. I don't know if project site or project are defined terms in the decision, but I think that would make the distinction between the public and the private sidewalks, and you would get out of the business of asking them to shovel things that aren't theirs.
I think that's a great idea, Tim.
Yeah.
Thank you. Actually, and I wonder, Tim, since you've raised your hand, and John, this maybe Tim could help us resolve the questions we wanted to confirm regarding sort of the jurisdictional findings and plans. I think if I have it right, we're just looking for just some sort of validation from Tim or Judy or Tim that we're all set on those. Is that worth?
I had brought the decision up on my phone. I was looking at it a little bit. So as long as you guys don't do anything that I want to chime in on in the next 15 minutes, I'll put a little attention on that. I think some of those findings, in a lot of cases are kind of, verbatim references to the regulations. So my head was turning to mush a little bit thinking about the 1.5% less than or more than. So I'm gonna try to solidify that for a minute. So I'll take a dive into that and I'll chime in when I'm done taking a look at that.
Yeah, and Tim, that's great. And even as much as the sort of recitation of all the regulatory requirements, even just things like the town being at 4.97%, right? Some of the factual points, just confirming that, those were all correct as well.
Yep. Well,
yeah, great. Thank you.
So
all right.
Have we finished with page 8?
Yes, we have.
Okay. How about page 9?
Page 9, yes. So on what is the first sort of full paragraph on page 9 for me, the one that starts at a minimum.
Yep.
This is the provision that requires the applicant to bring final plans and drawings forward before starting construction at the site. Right, and it says, at a minimum, they'll be in accordance with the peer review comments from the town staff. And it says if there's no response or comments that have been given to the applicant by the board within 30 days, it's deemed approved, which is understandable. But I wonder if instead of it having to be only the board that could respond, whether we could say, or the planning director or the board's agents. We have the right to designate an agent under A12. And I'm just being mindful of this perhaps being an administrative process where, either Tim as planning director or other town staff would be in a position to review and substantively comments on the plans on a timeline that the board might not meet.
Yeah.
Right, as we know, if plans come in, they have to get reviewed. We, the board, can't meet to get any feedback until they've been reviewed. And as a practical matter, my suggested change might be just to say that if comments haven't been given by the board, the planning director, or other, representatives of the town.
Okay, hold on one second.
So Brian, if I can just chime in there for a second. Sure. Joe Prondek and I, when we were reviewing this draft decision, and I think it was this one, it may have been another one, but Joe raised similar type issues to this regarding kind of, there's references to the board reviewing things. And we worked with Judy a little bit to kind of clarify some of that language. But I think, as there's a little bit of speculation in that conversation because it's like, what is the board's appetite going to be for actually kind of getting to the weeds on this stuff, or are they going to be interested in just having, either the building commissioner or the planning director or some combination of the two. So I just wanted to kind of add that bit of context that this is an issue that staff has kind of been talking about. So, I think it's definitely a good idea for the board to kind of figure out what its kind of level of comfort is with, again, things where it says the board's going to review this. Is this something you want to farm down? I mean, what I would say is, the Board of Appeals is staffed by the Inspectional Services Department. I'm right across the hall from them, so Joe can call me in whenever he wants. But if you want to sort of think about it that way in terms of who's actually enforcing and administering the comprehensive permit, is predominantly inspectional services.
We could say maybe we'll tighten it up instead of me saying other representatives of the town, which maybe is too broad. Maybe if we say if the board, the planning director, and the building inspector, if none of those three have responded within 30 days, it's the deemed approval. And that maybe is a tight enough list to give that applicant more comfort, but also not worry about us getting hamstrung by just not being able to get a review plus a meeting scheduled in time. And I think, Tim, that sounds consistent with what you're saying, right? The building inspector and you're all across the hall. You could connect and trade notes and be able to give.
Yeah, I think that'll do it.
All right, great.
No, I
Yeah.
think that's good as well. I mean, in all candor here, and I think Tim has put his finger on it. I don't think, maybe you do, Brian, because you deal with big real estate projects, but I certainly don't, and I don't think Mrs. King does. So having us review plans and other things from a technical perspective is a mistake, and it wouldn't be adequately reviewed. So I do think that putting in the building inspector, inspectional services is the way to go. Ginny, do you agree with that?
I agree with that.
Okay, great.
Tim, I think you might have missed the very tip of the meeting when we just want to just thank and just acknowledge you and Judy and Mr. Pronick and the whole team that put this draft decision together. You really did a thorough and thoughtful, really great job on it. So despite us little combing through lines here, you really prepared a great decision for the board to review.
This is 99.98% Judy. So we'll convey that the next time to her. But thank you. I appreciate that.
Great.
Anything else on page 9?
So A14 is the 6 parking spaces in the walking path condition.
Yep.
So what does it say? That the applicant has committed to creating, constructing, and maintaining 6 parking spaces in a walking path to access the existing Pine Brook Trail in the Milton Conservation Land, and keep it open to the public from dawn to dusk. You can temporarily close it for security purposes, right? Et cetera. I think we should add an obligation on the applicant to plow and to maintain the parking spaces in the walking path. I'm sure they'll have a contract they have for their own snow removal and landscaping and whatnot for the entire property, and it should be an obligation, I think, to maintain those spaces as well. And it had already said it construct and maintain. So I'm going to guess that's consistent with what the applicant intended anyway. But for clarity, in particular, looking years into the future with a transition to a condominium association, it shouldn't be the case that the condominium association could, abandon making the spaces available over time, because that's, I think, an important, public amenity from the project.
Yeah, I don't disagree with what you're saying. The problem is I don't have a perspective of what we're really talking about here. The parking spaces, it's obvious where they're going to be, but it says construct and maintain 6 parking spaces and a walking path in connection to the existing Pine Brook Trail on lands. Okay, so in other words,
just depicted on the plans. Yeah.
Okay. And so you want them to maintain and to plow that area.
That's right.
Okay.
And to plow, to maintain, and to landscape, to maintain the landscaping around the area.
Do you know the extent to which the town plows or maintains the walking path around or in the Pine Brook area land?
I do not.
See, I don't have the slightest idea there, so. I mean, it sounds like a good idea, but when the plow and maintain a small area that seems to be at least relatively small near the project where people would walk and park their cars and all of that.
I think
I assume that the landscape plan dealt with plantings and other.
that's probably right. Maybe this is really just a plowing and just kind of ordinary maintenance of the of the areas. I think what I'm thinking is this 6-space lot shouldn't be an orphan, right? They're going to have a landscaper. They're going to have a snow removal company, and the spaces really should get the same treatment as the rest of their property, even though they're intended for the public, right? If they're repaving or resurfacing their parking lot, they should include these 6 spaces. So that's what I'm trying to get at.
Yeah, I mean, that's an interesting thought. I don't disagree with you in the slightest, and I really guess that to answer your question really requires to look at the plans showing the 6 parking spaces and looking at the landscape plan and seeing what it provides. And frankly, I thought that the applicant's plans dealt with this issue in a pretty good way. I can remember the landscape architect talking about different plantings and bushes and all of that, but I don't know that you have to, I think you have to look at the actual plans and see what's being proposed.
I think the plans will speak to what gets constructed, right, and what they build. And I think the conditions go to, now that we've built it, what are our responsibilities for how we maintain it?
Right, but there's somewhere else in here it talks about, I'll call it green issues. How's that? And it puts an obligation on the applicant to replace dead trees and shrubs and other plantings. And I don't think it specifically references this particular area, but yeah, I mean, this is fine. I don't mind seeing that language in there. I don't think it imposes any serious obligations that the applicant hasn't already assumed.
Yeah.
It sounds reasonable.
Okay.
My thought is that we're refining this agreement as we should, but I think that the direction we're taking here is one that we're going to have a redrafted agreement and have that reviewed, because I think we're going beyond rather minor edits in the agreement as drafted. What we're doing is we're refining and maybe redefining concepts that are here, but we're really amending this agreement in a manner that's beyond de minimis. I'm not saying we shouldn't do it. I think we should do it.
I actually think, John, we not only, obviously we should make all the changes we think are appropriate, but I think we're able to describe them on this meeting in such detail. In fact, I think we're using greater detail than we often use at our non-40B meetings to describe what a decision should say, and then we write the decision after and are comfortable signing it. I think if anything we were discussing today was conceptual, then and we really needed some time to refine it, then I think that's right. But and maybe we can decide this at the end when we've seen the totality of the edits.
Yep.
But I think at least the comments I have will be sort of discreet and straightforward enough that we could be comfortable, with the record of having discussed the changes, voting to approve and just signing it with, a matter of typing in the edits.
I hear you, and in some respects, I agree with you, in other respects, I don't. And my concern here is that we have a document that that we agree is reasonable, that Judy understands where we're going with some of these things, and can help us to some extent, and also that the applicant has an opportunity to see what this language actually provides, and has an obligation to strike it, has an opportunity to question or suggest that our language is too small, too narrow, too broad, or whatever it is. So that's my concern. I don't, from the direction that we're going, and I'm not critical in the slightest, I think this is where we should be going. That's the whole purpose of discussing this decision, is I don't want to put either the board or the applicants in a position that we're voting to adopt a decision where there are some issues that may be of some significance or some refinement, and that's being adopted into the decision by reference or by general concepts of what we're discussing here now. So I hear what you're saying. I think we should be doing this, and I don't think Judy will be upset. And in all candor, I think this is a wonderful decision. But I certainly see that somebody with your talent, skills, and foresight in matters like this can raise interesting issues that are well worthy of discussion, which we're doing here now, and worthy of amendment of this agreement so that we feel comfortable with it. But all I'm saying at the present time, my concern is I think that in fairness to the applicant, we should go through this, finish it up, and then I'll go back to Judy and discuss these things with her and get some language and get a revised agreement and circulate that. And I guess everyone should be on board, or if there are objections or concerns, they'll be relatively minor and we can get this decision done. But I personally feel very uncomfortable voting for a decision where the language involves substantial work, and or refinement, and I don't know what the language is. That's my feeling. But why don't we go on, and I think your suggestion is a good one, that let's see where we are at the end and see how we feel. Okay, so how about, have we finished page 9?
We have not. The other, again, because I think this parking commitment that the applicants is one of the greatest, sort of community benefits from the project, and where we've said that the 6 spaces will be open to the public. These spaces also could be just very convenient spaces for people who live in the building. I think the intention is that they're supposed to really be dedicated to the public. So they really should be restricted not to be used by residents or their visitors. The 6 spaces should be left available to people from the public who intend to use the recreational facilities. And I'd be, Chairman, Jen, I'd be very happy to hear what you took away from the hearing. But what I took away was the 6 spaces were, for example, not used in the parking count for the apartments.
Well, I think that's exactly
Yeah.
right. And I think your practical experience here is probably good, because depending on where your apartment was, you can certainly see people parking there and running up to their apartment and getting tied up on whatever it may be, and all of a sudden the public access is diminished. Yeah, so I mean, I think that's an edit that that's constructive, and I think it's what's intended by the applicant here, and I think you just further defining that, and I think that's a good thing.
Excuse me, excuse me.
Yeah,
Um,
good.
yeah, Adam has his hand up.
Sure. Adam, do you want to be heard?
Thank you, Mr. Leonard. I'd simply point out in paragraph A14 that we agree to maintain signage stating parking for trail use only. So the parking is to be restricted for the public for trail use. And I don't think we have any problem with adding the word plowing to construct, maintain, and plow the 6 parking spaces. The intention is to maintain that as a public accommodation. Thank you, sir.
Okay, thank you. I appreciate that. That's very helpful.
That
Ginny,
is helpful.
are you all set with this?
Before we leave this is just a tiny little nit. It's the brook is called Pine Tree Brook.
That's good. And it's a good catch, Jenny. Thank you. Just just to make sure I was clear, I was going a bit beyond what I agree that the signage is helpful, that the obligation is to put signs up, but as the decision says, the condominium documents are going to recite these conditions. And so I think it's helpful that it's not just that they have to put up signage, but they're acknowledging that they're restricted not to be used. And 14A will be open for the general public from dawn to dusk, and will be restricted, not for use by the residents and their visitors.
I don't have any problem with that. I understand what Mr. Brodsky said. I appreciate his agreeing to plow. I don't think it's a matter for the protection of the public. I can see people parking there. If you didn't restrict and dedicate that, I don't think that's an undue burden on anybody. So I agree that the language should be in there. Okay, so where are we on page 9? Are we?
I don't have too much more. I don't have anything else on page 9.
Jenny, do you have anything on page 9?
No.
Okay. Page 10.
So on page 10 in paragraph B2, I think it's supposed to be 13 homeownership units, not 11 homeownership units that are included in the subsidized housing inventory.
Yeah, I caught that one.
Okay, yep.
And I don't have anything again until page 13.
All right, so how about anything else, Jenny, on page 10?
No, that looks fine to me.
How about 11 or 12? Okay, so we go over to page 13.
On page 13, paragraph C3, clause A. This is the paragraph that requires the applicant to submit the condominium, the draft condominium deed and declaration of trust to the board's council. And again, it's the point we've discussed a few times why it's important, because I think once the project's constructed, it's really the association that'll be following through on this. So this is a good and important condition. I just think it says submit, but I think this should be, with review and confirmation by the board, similar to the concept we have with the final plans and specs, right? So earlier we saw that the final plans get submitted, and I think a deemed approval concept is fine. The applicant can't be stuck in waiting indefinitely. But I think the same concept that much like they provide final plans and specs to the board for approval, and I think the approval is just limited to confirming the consistency with the conditions. Mm-hmm. We should have a similar review of the final condominium documents. And if we, the planning director and the building inspector don't, or I suppose in this case, the board's council don't respond within 30 days, the very same construct we have with the final plans, then it would be deemed approved.
Okay, so you want to leave board's council in there.
Yep.
Also add the building inspector and the inspection services.
Yeah, I think I think it's just adding another sentence. It's the same concept from before, which just says that the condominium documents will be subject to the prior approval, subject to the board's council's confirmation, right? We don't have a subjective right to weigh in other than just to confirm that they're consistent with the conditions, right? Much like the final plans just have to be consistent with the current plans. So we just want a chance to review and confirm they're consistent. And if we, have failed to give such confirmation within 30 days, then they'd be deemed approved.
Okay. Jenny, you agree in agreement with that?
Yes, that's great.
Okay. Anything else on page 13?
Nothing else on page 13.
Okay. Page 14.
I actually don't have anything else until page 18.
Okay, so Jenny, do you have anything on 14?
No, I don't.
Okay, I don't. 15? I don't on 15. How about 16? Okay, and Brian, you're on page 17 now?
18, actually.
Okay, I'm still 17, I have nothing there. On 18, go ahead.
So in G8, where it says project shall secure, I think we should say the applicant shall secure.
Yep. Okay. That's fine with me. I assume it's fine with Jenny.
Mhm.
Anything else on 18? No?
I don't have anything else until the Exhibit A waivers.
Okay, let's see. I have nothing on 19 or 20. Jenny, do you have anything on 19 or 20?
I do not.
Okay, so we're gonna go over to the waivers.
And I don't know if this is just a change we discussed at our August 19th meeting that just didn't get caught, but you'll recall we had a discussion about the stormwater management bylaw in Milton. And the applicant said they no longer needed to ask for this waiver. It's the very last waiver on page 23.
Yep.
We had this discussion on what's the gap between the Wetlands Act and the permit and the plans, et cetera. But in the end, we were able to not have to make a decision on whether or not to grant that waiver because the applicant said they no longer needed it. So I think that last waiver comes off, the waiver of the Milton Stormwater Management Bylaw.
I think you're right there, but I have to look at my notes on that one. But I think you're correct. Jenny, do you have a recollection of that?
I don't. I don't offhand, no.
Okay. Well, I'll certainly check my notes. I think I agree with what Brian
This was-
is saying.
If Tim's available still. Right? This was one where I think there was, I can't recall if it was the building inspector or the public works director had expressed some concern about the blanket waiver from the stormwater bylaw.
Yep.
And right, and that was so we had some discussion about whether or not it was appropriate to waive it, but then in the end it became moot because the applicant said that they actually didn't need the waiver. So we were relieved to not have to sort out that disagreement.
I have that in my notes too.
Okay. Thank you, Bev. That's helpful. Brian, anything else?
That being the last line, I am out of comments. I appreciate everyone's patience.
Okay.
But it seemed worth reading in detail after all this time.
Let me suggest this from my thought. I think we're in agreement with 99.9% of these things. I think to try to simplify this, if you can simplify it, and at the same time move this matter forward. I have my notes here. I think there are two ways to proceed. I can take my notes and sit down with Judy and run through all of these things with the possibility that they could become muddled more because of what I'm saying as opposed to what we discussed. So does it make any sense, Brian, for you to take this decision and interlineate the substance of our issues here?
Yeah, I'd be happy to do that. I'll even do it right after we adjourn while it's fresh in my mind, and I have my notes in front of me to make all of the revisions we've discussed.
Yeah, and I think if you do that, two things are going to happen. One, it is going to be absolutely clear what we've agreed upon here. And it would be really helpful, I think, for Judy Barrett, who's a warrior, in my view, so that she won't have to rewrite this 2 or 3 times and we go through the same process. I don't think it's necessary. And I think if you put in here clearly what would the substance of what we've agreed to, Ginny can read it, I can read it, but then it would be a lot easier for Judy to incorporate these things into a decision so we can get a copy of the proposed decision to Adam so that he can review it with Mr. Bosworth and feel comfortable about this. Does that make sense to you?
It works for me. I've got no objection to that. I am, being a little mindful of so I would be comfortable just voting to approve the draft decision with the changes that in this recorded meeting we have discussed. If there was a time sensitivity from the applicant, given how long this hearing has gone, but I'm also very happy to reconvene. I know we have a meeting scheduled on the 30th of September. So if you think it's more appropriate to actually see the edits before you vote, I don't have an objection to that, but I'll just say I'm also comfortable, and I think it would be consistent with many practices of boards to approve a decision with such edits to follow. In any event, I'll go in either direction that you feel comfortable with, Mr. Chairman. But I do want to say I do think if we wanted to, we could do that.
Okay, no, I appreciate that. I appreciate the benefit of your experience. I think this I would tend, looking at the time we've spent on this and the money and experts that are all involved in this case, that and we've come a long, long way. I think unless the applicant was comfortable with that, and we know Mr. Bosworth isn't present tonight, I think I would prefer to have the final decision, quote unquote, circulated, and then make sure that everyone's on board. On the other hand, I understand how things act in the world, how they work in the real world, and I know people could do what you're suggesting, but I wouldn't want to.
Yeah, that's
I don't want to.
fine by me, Mr.
I don't
Chairman,
want
yeah.
to impose that on Mr. Brodsky. So
Yeah, no, that's fine.
With,
Excuse me, Mr. Brodsky's hand is up.
yeah, well, I'm sure it is, because that's what I want to ask him. Do you prefer to have the opportunity to read what is probably going to be the final decision, or are you comfortable proceeding as Brian suggests that maybe businessmen in the real world would act?
Thank you, Mr. Leonard. I've been carefully noting all of the changes and none cause me any concern whatsoever. I would simply, with that said, I'd just ask Ms. Driscoll to weigh in and confirm that she's comfortable proceeding. We would like to have the board vote this evening because if we continue again, it's going to delay our Conservation Commission approvals.
Okay,
And that's the real limiter here. And I do want to note that with respect to the number of affordable units, each and every time we get a draft, we correct that number. And for whatever reason, I can't explain why it reverts back to the number 11. It is the most bizarre thing, but we've talked about that no fewer than 3 or 4 times. And we've all noted that that should be corrected, but thank you for picking up that correction. So with that said, Ms. Driscoll, are you comfortable with the board voting, or would you like to wait and see the final decision, which would require that the hearing be continued to the end of September, which means that we'd also probably have to continue conservation until October?
Thank you. I'm comfortable with the board voting today. I did not have any concerns from the things that were brought up.
okay, all right, that's fine. Why don't, let's not get ahead of us. There's one additional issue here, and that's Mr. Brodsky's suggestion about dumpsters and all of that. Do we want to deal with that?
I think so.
I don't think
Maybe this is actually, this may be why our pagination was different. I believe that Judy sent a second revised draft, Mr. Chairman, this afternoon in response to make that, what I think is actually just a correction, not a substantive change, right? So the draft that I had removed that sort of errant reference to the curbside trash.
Yep.
And so I think it'd probably be good for us. Actually, it's a good point. For the record, we should just sort of acknowledge the decision we're reviewing. Does account for trash being handled as shown on the plans, not requiring curbside trash removal.
Okay. All right, then I think so everyone's comfortable on voting this.
Mr. Chair, I have 2 quick corrections. I went into the sections that I was asked to.
Yes, please. Thank you.
So just 2 things that I noticed to Mr. Connolly's point in section 313B about the sort of statutory minimum regarding the land area. I do think that should say more than. And just to sort of have the 3 of you confirm my reasoning, that's the general land area minimum under the statutory minimum. There are 3. There's the unit count, there's this land area, and then there's certification of a housing production plan. For the general land area minimum, the requirement is if more than 1.5% of the total land area of the town, which is zoned for residential, commercial, and industrial use, is comprised of affordable housing sites, then you get safe harbor. So to say that, the board received no evidence that existing affordable housing units are on sites which comprise more than 1.5% of the total land area of the town, means that we have not reached the statutory minimum. Right. Does that make sense?
Yes, that's also how I read it, Tim. So thank you for confirming that.
Okay, so I would make that change, and then the other one is super minor in D in that same section 313. There's a reference to provisions under 524 CMR 5603. That should actually be 760 CMR 5603.
Right.
Yep. This is one of these things where I Google 760 CMR 56 every other day. So I was like, wait a sec, I've never looked at 524. That's actually elevator regulations. So if you're ever interested in that, you can go check those out. And so those are the only 2 in those sections that I found. The only other thing that, is just an unfortunate timing sort of thing, that 4.97% is going to change, but we don't have the official numbers from DHCD. It's actually going to be lower. It's going to be closer to 4.0 8 something. But that's the number that's accurate as of the most recent authoritative data that we have right now. So I wouldn't make a change on that.
I think what really matters is that it's accurate for what it says. That was the number on the date, and it's less than 10% in any event. And I think those are the material points, right?
Yep, absolutely.
And it's in Tim, so otherwise, just the factual things, the town being at you just confirmed the 4.9%. And then in paragraph D, for example, where it says no affordable units have been added since February 12 of 2020, that's also accurate.
Since February 12th, 2020. Yes. Well, I would actually have to go. We may have added 2, but that again, functionally for the purposes of safe harbor under the housing production plan, that clause is 100% accurate. It's just I would have to look through my records and see if we actually got credit.
You probably don't need to say it. Would you be more comfortable if we just struck that sentence that starts with more specifically?
Most specifically, Town of Milton as a JCD. I would maybe just to, because I do think it's important to reference because there are 3 statutory minima and we referenced the other 2. Yeah. And so I think it's important to leave that in, but I may just change that last clause to something along the lines of not enough affordable units have been added to the Milton subsidized housing inventory to qualify for a certified housing production plan. If the board's okay with that, I mean, I can wordsmith that language.
I'm content with that.
Okay, I'll make a note to do that. But that's basically it. That we need to add 48 units in a calendar year to get safe harbor under that statutory minimum, and we have not. So it'll be language reflective of that.
I'll take a crack.
And that's all I've got.
Okay, that's great. That's great. Ginny, are you content with all of this?
Yes, I am. I'm happy that everything has gone so well and there's so much agreement.
Well, as am I. But let me ask you, Brian, just not to put you on the spot here, but just so we know where we're going, that I understand what you're going to do is take this decision. I hope it's in Word format, but I don't.
It is, yep.
Then you're going to produce for us 2 copies. The first copy is going to be a copy of this decision with your and other suggested changes that we've agreed to here, inserted in a conspicuous manner using your systems, your computer systems that I find mysterious, so that Judy would be able to look at that first version and see the changes that were made and could understand. And if she wanted to comment on the changes, that's possible. I don't want to give her a quote final document and say this is it without kind of giving her a heads up of the changes that we've made. And I think that's kind of courteous and deferential to her. And then the second document will just be not a redlined copy, but a final copy ready for execution. Is that what you intend to do?
Exactly.
Okay, that's fine. And I know it's 10 minutes of 9. I just hate to put you, through this.
This won't take too much time at all. These are just some pretty quick edits, I think.
Well, this is amazing because I deal with some people in the City of Cambridge Law Department, and it's the same thing. They're computer wizards, and they can insert and take out and change and reformat like they're playing a video game or something. So I congratulate you on your skills. That would be helpful. The only downside of it is you may miss Tom Brady in the second half of his Tampa Buccaneers game
it-
tonight. But,
It might be the first time in my life I've got a compliment on my technical skills, so I'm enjoying it. I'm not used to that, so it makes it worth it.
well, maybe it's because Ginny and I have the skills that some people would think are prehistoric. But, I certainly admire what you can do. So the way we will leave it is that you will prepare one showing the changes, one showing final. Let's say you do that in the next day or so. I mean, maybe you'll feel tired tonight or whatever, but within a short period of time. And then you'll send that to Bev and we'll circulate that to the board members and to Mr. Brodsky and, give Adam and Miss Gerald, I think it is, time to look at that. And if it's in order, we'll get it signed up and get it filed as on an expedited basis. Is that fair with you, Mr. Brodsky?
Yes, Mr. Leonard, thank you.
Okay, great. Then let me ask, is there any further issues to come before the board on this particular application? And I guess there are none. Ginny, you don't have any further comments? So,
No, I don't.
Okay, great. I want to thank everybody for their participation. I really want to thank Brian.
Mr. Chair, do you want to vote to approve it or?
I think we should. Yes, I think we should, though it's an approval based upon additions to be made in accordance with oral.
I didn't want to step on any toes there.
No, no,
My
no.
understanding from what you were talking about earlier was that there would be a vote and then.
No, I think technically you're right, because otherwise we'd have to reassemble the board. And so why don't we do this if you're comfortable with it? I mean, I wouldn't do this unless the applicant's totally comfortable with it. But I would make a motion to approve this particular 40B application pursuant to the draft decision of Judy Barrett dated September 9th, 2021, with the additions, I'll call them technical additions and refinements, which have been discussed and unanimously agreed upon tonight. So that's my motion. Is there anybody who seconds it?
Second that.
Okay, then all those in favor of the approval of this 40B decision with those conditions, please say aye.
Aye.
Aye. So, okay, so we voted the approval of the decision, but I will tell you, Mr. Brodsky, that despite that fact, we're going to give you the opportunity to review this decision in its final form to make sure it's consistent with what your memory and intent is. And after that, I don't think we need a meeting to do that, but if you have no objections, we'll give you a couple of days after you receive it if you want to make objections. But if you have no objections, then the board will circulate the decision for signing and filing with the town clerk. Does that make sense to you?
Yes, Mr. Leonard, thank you very much, and thank you for your consideration.
Okay, then that's great. So if there's nothing further to come before the board, I think I heard a motion to adjourn this hearing from Mr. Conley, and I think
Seconded.
And it's seconded. So all those in favor of adjourning this evening's hearing, please say aye.
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 Oh, there's a hand up.
Who's hand?
It went away.
Wait,
Yeah.
oh, yep, I'm sorry. I had the attendees opened.
Oh, wait a second. Yeah, but the attendees are not,
No, I hear.
they're not participants in this portion of the hearing.
Right, so I think we have officially adjourned the meeting.
We have indeed, and so I want to thank the applicant and all of its assistants, and really I thank Mr. Conley for his words of wisdom here. They're much appreciated, and everyone's service on this application. So we'll get the final decision out for final review and comment, and then get it signed up. So thanks everyone, and have a very good night.
Thank you, Mr. Leonard.
You
Thank
too.
you, everyone. It's been a pleasure working with you on this project.
Thanks. Same here. I wish they were more of this vintage. Thanks.
Yeah.
Bev,
Thank you.
Bev, do you have anything you want to add?
No.
Okay.
Thank you, Bev. Really appreciate all your help.
Go on,
Thank
Kate, tomorrow.
Okay. Have
All right,
fun.
thank you.
We're adjourned. Thank you.
Take care. Thank you.
Yeah.